And for that reason, I'm really excited that I get to introduce today Martin Husevec. He is an assistant professor at Tilburg University in the Netherlands, and he works at the intersection of law, technology, and economics. He's an expert in intellectual property law, in how IP affects competition and innovation, and in the interrelationship of fundamental rights and IP. He's an affiliate at our center, as well as at the Max Planck Institute for Innovation and Competition, and he's been a part of impact litigation efforts through the European Information Society Institute, which is a Slovakian nonprofit that does impact litigation, working for freedom and the public interest in the context of technology law. So in short, Martin is a rare person that we at CIS love, somebody who is an excellent scholar, an impactful advocate, and a huge fan of freedom, liberty, and the public interest. Today, he's here to talk to us about the evolving intermediary liability law in the European Union. So thank you, Martin, for coming.
Thank you very much for this very kind introduction, and thank you for having me. I'm really looking forward to share this research with you because I'm quite passionate about it. It embodies quite interesting legal scheme that impacts and will impact innovation, and although it's now particular to Europe, it might also come to the United States at some point. So let's see what we're going to talk about today. I'd like to talk about a special type of remedy that is now gaining momentum in Europe, and especially is gaining momentum in the field of intellectual property law. Now, the European Union is very eager in exporting it, and we have seen it in ACTA, where the provision that I'm going to talk about today was proposed in the legislative text. And Europe is also exporting it within the bilateral trade agreements to some third countries. Of course, at the same time, US right holders are becoming envious of this remedy here in the United States and are increasingly demanding it. So it's something that might be also relevant here at some point, at least on the level of debate. Now, what this remedy is about? This remedy is about a possibility of right owners to ask people who did not infringe any rights to do something for them, to give them certain assistance and enforcement, and hence contribute to enforcement of IP rights. And I'll try to explain that in a little bit more detail, also on examples how that works and what it does for the internet policy. So the basis of this duty is not liability. The basis of this duty is not wrongful acts. The basis is the mere fact that you are in a position to do something for the right owner, and that's enough. So that's why I call this remedy or this phenomenon accountable. So accountable for some help, but not liable, because you're not liable for actions. And let's jump into example that will maybe illustrate this this phenomenon. So I'd like to start with a story that originates in Germany. In 2010, German Federal Supreme Court decided a case about the copyright enforcement, and it was a case about question whether an operator of a Wi-Fi has to password protect the Wi-Fi in order to prevent third-party infringements. So regular scenario, you have open Wi-Fi, someone goes and misuses the Wi-Fi for file sharing or something similar, and the question was, does this person have some obligation to secure the Wi-Fi or take some additional steps to prevent those infringements from happening? Now, of course, similar as in the US, also in the EU, mere conduits are not liable under the Commerce Directive, so something like your DMCA. They're not liable for monetary relief, so the Wi-Fi owner didn't have problem arguing this part. But the part that became more important was the second part, where the court considered that even though the person who opens up a Wi-Fi is not liable for whatever the third parties do with internet connection, despite the fact that he's not liable, he has to do something for the right owner. And this something was to password protect the Wi-Fi, and actually using quite strong encryption. So some basic encryption wouldn't be enough. Even passphrase had to be longer than usual. So as a consequence, what happened is in Germany, it became a standard to have a password-protected Wi-Fi. Why? Because if you wouldn't have a password-protected Wi-Fi, you would get a cease and desist letter asking you to password-protect your Wi-Fi. And already the fact that you received that letter would be subject to compensation because of how in Germany pretrial costs are being compensated. So consequence, in Germany, there is a very low availability of open Wi-Fi even until today. It's very difficult to find hotspots because everybody uses some form of authentication. And of course, Germany very soon realized that this is not the best policy because open Wi-Fi has a potential for innovation, but also for competition. And these days, there are attempts on the legislative level to change this. There are also attempts through judicial routes how to change this. But keep this example in your mind when I'm going to talk about the remedy itself, because this nicely illustrates the basic problem behind the remedy. Someone is not liable for the actions of users, but nevertheless, he's asked to implement certain measure. Can be very costly, but does not have to be, like password protection. And this measure has a certain influence on follow-on innovation and also on the situation of the parties, of course. So what this case, where this case has a very big potential to produce substantial costs is on the side of innovation. Why? And competition as well. Why? Because if the ruling is taking further, understood as no wireless communication that without authentication is possible, because you can always misuse such wireless communication for infringements. If this is the rule, then a lot of innovation that is based on communication, wireless communication without authentication can be put in jeopardy. Example is, for instance, communication between cars, so car-to-car communication, pedestrian-to-car communication, mesh networks. Actually, as a matter of fact, in one case, which I'll show you later on, when we were writing and drafting together with EFF a letter to the Court of Justice in one case, I spoke to people from Red Cross and one guy who was developing a tool for disaster management. So basically, after disaster, usually cell networks are down and networks in general are jammed. And he developed a certain mesh network which made it possible to have a good after-disaster management. And he was, from technical perspective, arguing that this kind of ruling, if implemented properly, would make his tool that was celebrated by Red Cross impossible also in Germany. Of course, if someone would really enforce this law against this. At the same time, you can also clearly see examples where this kind of ruling can have effect or negative effect on competition. So think of Republic Wireless, which is a US company that offers the service where basically use as your primary communication channel for calls, voice over IP by using public Wi-Fi, and only if there is no Wi-Fi you fall back on the cell network. If you have no public Wi-Fi, you cannot build up this kind of system, which means that you cannot create a cheaper alternative to cell networks. Because of course what Republic Wireless does, it provides a means how to compete with the cell network providers who are of course charging completely different prices because the pricing is done differently than if the most of the communication goes through voice over IP. So you see here that both innovation and competition can be very easily put in jeopardy just as a consequence of one simple measure coming from the copyright field, which is basically password protect your Wi-Fi in order to prevent misuse. Now what is behind this is this provision of the Information Society Directive. Information Society Directive is a general copyright directive from 2001, And in Article 8.3, paragraph 3, it has this particular sentence. Member states shall ensure that right holders are able to apply for an injunction to be addressed to intermediaries whose services are used by third parties to infringe an intellectual property right. When this sentence was inserted in the law, it was not very clear what that really means. So most of the member states took it as meaning that they just have to grant injunctions against intermediaries, but it's up to them really to decide when that is really the case. Slowly, through the developments before the court, but also when you really look into the legislative history, it became clear that the intention was very different. Intention was to have a remedy against intermediaries, irrespective of the fact that they infringe somebody's rights. So irrespective of the fact that they are primary or secondary infringers. And actually, this is where we see today that this provision has most of the most intensive application. It's exactly in the situations where there is no direct or secondary infringement happening on the side of defendant, but you nevertheless try to force a certain technical measure on the provider. This provision exists not only in the field of copyright, but also for the intellectual property rights in general, thanks to Enforcement Directive that has the same provision, and now we also have it in the unitary patent system. Now you would think that this kind of remedy is very counterintuitive because, well, it grants you certain relief against someone who didn't do anything blameworthy. But the interesting thing, if you look at both common law and civil law, and here I just put common law on the screen, it's not so novel. So there are instances already early back in the history, also in common law, that came up with a very similar logic. So this is a leading case. You might know this case, Norwich Pharmacal. Norwich Pharmacal was, and you might also know Norwich Pharmacal orders. Those are the orders for disclosure, and usually for disclosure of information from a third party that has nothing to do with infringement, with infringing action, but nevertheless holds some information that is important to litigation, and in this case was IP litigation, patent litigation. So Norwich Pharmacal came about because there was a harbor that had certain information about who the infringer might be, and plaintiff did want to know the identity of the infringer, so it asked the harbor to release that information. Harbor was reluctant, and eventually it ended up in litigation. And the House of Lords eventually ruled that there is a duty on the side of the harbor to release that information, and this is how they reasoned. So if through no fault of his own, a person gets mixed up in the tortious acts of others so as to facilitate their wrongdoing, he may incur no personal liability, but he comes under a duty to assist the person who has been wronged. Okay, so you see that it's deeply rooted in the equity. I mean, this is equitable relief that a court is interpreting, and it's saying the fact that you get mixed up in the transaction and you yourself did nothing wrong does not mean that you don't have some equitable duty to assist the person who has been wronged. In this case, as I said, it was about information disclosure, but we see today this was also extended to other kind of assistance. For instance, assistance by blocking a website as an internet access provider. And it will definitely have in the future potential for all kinds of cases you can think of, especially with respect to intermediaries who are further from the infringement, so who usually wouldn't be in reach of other remedies. Now, the interesting thing is if you see the justification that a court offers is that court says justice requires that he should cooperate in righting the wrong if he unwittingly facilitated its perpetration. And you see very strong, and also when you look at a civil law, you see very strong justice proposition, that this is something that is a matter of justice that should be available as a relief. So it's, the bottom line here, it's not something novel, it's something that exists, but we are now extending it further and extending it to IP enforcement and making it a very broad duty of assistance that is enforceable before courts. So how can you think about this? And coming from the US background, think of your DMCA, which is our e-commerce directive, which shields certain types of services, shields them from liability. And Of course, many services are also implementing all sorts of enforcement techniques, whether unilateral or bilateral or multilateral. They're going beyond the DMCA. So they are not necessary from the perspective of complying with the DMCA, but providers do engage in them. So for instance, YouTube's development of Content ID is an example where YouTube developed the system, fingerprinting technology on top of the regular notice and takedown in order to be able to flag proactively different material, copyrighted material that is uploaded to its platform. Or think of the copyright alert system, so the system which was agreed upon between internet access providers in the United States, which also creates a system. I don't think it's only about passing notices, right, to the users. So it's not about disconnections. Or is it also about disconnections, potentially?
No disconnection, but some throttling.
Okay. So nothing yet. No. Okay. All right. So these are kind of voluntary measures, or DMCA plus, as they would call it today. Now, those kind of measures are measures that are not necessarily voluntary anymore from the European perspective, because Article 8.3 of the InfoSoc Directive and this injunction provision against intermediaries is the provision that allows you to force those measures on the provider. So if website blocking or disconnection from the internet access provider is something normally voluntary, you can actually go to the court and ask to force the defendant and internet access provider to implement the same thing on the basis of this provision. And we actually have those cases, so it's not a theory. So what happens is basically you are taking this realm of voluntary measures and turning it into something that you can litigate in the court, because you can turn it into legal assistance in the enforcement. Now, there's a big difference between two different situations here. There are voluntary measures which are applied by what I call proximate providers, and there are voluntary measures that are applied by what I call remote providers. Who are they? Proximate providers, those are the providers who have to act already. They have to act based on notice. So if they receive a valid notice saying there is a copyright infringing material on your service, they have to act and remove that particular information. Otherwise, they will incur liability, okay? Regular tortious liability. So in order to avoid that liability, they have to act upon notice, and they will be fine from the liability perspective. Now, remote providers are different. Remote providers are providers who, even if they receive a notice, they don't have to do anything. So typical example are internet access providers, right? If there is a website that is infringing, and internet access provider facilitates access to that particular website, and you send even a notice to, let's say, AT&T, well, AT&T doesn't have to do anything in order to comply with the DMCA, right? It can just look and say, well, okay, well, it's available, so what? I don't have to do anything else. Of course, they can agree in voluntary agreements with right owners to terminate and to block access to these websites, but it's not that the DMCA forces them to do so. So this is the distinction, and it becomes very important because those who are already exposed to liability have to take certain precautions as a matter of tort law, whereas the remote providers are usually exempted from taking any precautions because that's the design choice that we have taken as a policymakers. Usually, you could argue that the reason behind this is something coming from causality, so they are far from the actions, infringing actions, so that's why we are completely exempting them from duty of care and from the potential scope of tortfeasors. But that's not important here. The important thing here is the proximate providers are those who have to act upon notice to avoid liability, whereas the remote providers don't have to act even if they have notice. So let's go to proximate providers and what this kind of remedy does with proximate providers in Europe. So typical examples are hosting providers, information location tools in the United States. So typically, under DMCA or e-commerce directive, intermediary obtains a valid notice, so sufficiently clear, substantiated, and whatever. And it has to make a certain decision based on that notice. So it's a two-stage process. You first have a notice, then you have a decision whether you take it down or you don't. Now, what does the injunctions do? These injunctions are trying to force filters on intermediaries. So they're trying to collapse the two-stage process into a process or into an affair of one man, namely of an intermediary here. So they try to say, intermediary, you have to do everything on your own. You have to flag the potentially infringing content, and you have to block it of your own initiative. Okay? So this is something that it's these days being labeled as stay down principle. So how it's usually being explained is a stay down is a principle under which you send a notice to a hosting provider. Hosting provider now has to not only police this particular instance of infringement, but also has to take care of any infringement of that particular work in the future. So it has this sort of a permanent effect. Now, this is something that these injunctions are implementing as we speak in form of court orders already. So we don't have it in the e-commerce directive, so it's not implemented in the liability regime, but different courts are issuing injunctions that force intermediaries to implement all kinds of filtering technologies in order to prevent another instances of infringement of the same work. So basically the stay down principle. What is interesting about this is that the most prominent jurisdiction for these injunctions is Germany. And in Germany, you can see that the policing is going as far as to force intermediaries to even search for third services. So let's say for some specialized search engines, they are finding links on your file hosting service. And so they are forcing these intermediaries to even search for those websites to find possible links leading to your website that would contain copyright infringing material. So you don't have to only police your own website by looking into on your own website, but you also have to look at the other websites and how they engage with your own website. So it's going rather far. Now, what this does in reality is basically it takes as I said, it takes this two-stage process and it transfers the cost of submitting notices onto intermediary. So intermediary has to now do two-stage process on his own and of course has to incur the cost. But what is interesting here is that the argument that is always put forward in support of this is, for instance, this from the US Copyright Office's communication of this public consultation that is ongoing. And one of the arguments is that many small copyright owners lack access to third-party services and sophisticated tools to monitor for infringing uses which can be costly and must instead rely on manual search and notification processes. So what they argue is that submission and the cost of submission is very high. It's prohibitively high for small right owners who cannot afford to do so. And since they cannot afford to use automated tools like Audible Magic, they spend a lot of money on the submission. So that's why it's a good policy to elevate it and to transfer that cost to intermediaries so intermediary would do it. But one thing they completely forget is that if they do this, they create completely different setup and environment for developing of these technologies. So if the stay down becomes policy, then who would be interested to develop these technologies are only intermediaries. Why? Because, well, they have to comply with the stay down, so they have to have some form of technology. And as you see today, the market for these technologies is actually rather, I mean, the market is big, but there are very few technologies. So most of the companies start with Audible Magic, and then they try to develop something of their own. And if they develop something of their own, like Content ID, they're not too eager to license it outside. Why? Because it's a competitive advantage. So of course they wouldn't do it. And you see just today or yesterday, Facebook released its own rights management system. And this is something that will be happening with all the services. So they try to develop these technologies and keep it in-house as they competitive edge compared to other services. And of course, under this setup, nobody, apart from Audible Magic maybe, which already exists, will be interested in developing it and licensing it to right owners. Why? Because there is no interest in using automation on submission side. Why would you have automation on submission side if they already have obligation to submit, if already intermediaries have that obligation? So consequence is that these tools won't be available. And since, of course, not all the intermediaries will implement the stay down, because it's impossible already from the jurisdictional perspective, you will always have the problem of sending notices, and you will still not have those tools available, because they will be in those companies. So actually what makes much more sense than that, if you're serious about achieving something similar, so trying to take advantage of automation, which is something inevitable, what you do, you try to allocate responsibilities here in a way which make the market for these technologies bigger. And what is that allocation? It's the allocation with where those technologies are used by the right owners, because they're plentiful of right owners. It's a fantastically huge market where many right owners might be interested in actually coming together and developing those technologies. Actually, interest groups can develop those technologies. And if they do use them in the arenas where these technologies make sense, so where the technologies have very small false positives, well, that's a win-win situation. And of course, when these technologies, when this market becomes more competitive, you might have also these technologies being cheaper. So these technologies will become cheaper and more readily available. So the consequence of stay-down policy in the reality is the fact that those technologies will become even less accessible. So the right owners will be locked in, and one of the problems, additional problems, is that, of course, individualized enforcement is something that will still be very important for the right owners. So individual enforcement is basically, you don't want to enforce against every single instance of infringement that is taking place, because it's not hurting your business all the time. There are many infringements, fan fiction or whatever, and you might not always be interested in enforcing your rights against them because it actually helps your business. Well, if stay down is implemented by intermediaries and they completely blindly follow the law, they might actually go against your business model. So you want to have individualization on the enforcement side. And this is something you can only achieve if you have a two-stage process. So automation on the side of submission, but also automation on the side of evaluation. Of course, only there where it makes sense, because not everything you can automatize. Okay, so this is for the stay down. I think one big message here should be that these injunctions are really capable of bringing that stay down principle, and they're already bringing that stay down principle to intermediate liability arena in some countries, and potentially any European country can have stay down today. There are some limiting factors, but surprisingly, they don't come from copyright policy, they come from fundamental rights. So for instance, right to privacy can mitigate use of filters, whereas copyright policy itself does not limit the availability of filters. So rather, external limits of fundamental rights are something that can shape this policy, but not the copyright policy itself. But now let's go to the place where these injunctions make the biggest change. They make the biggest change when it comes to providers who do not have an obligation to act upon notice. So the remote providers, as I call them here. Now these providers, such as AT&T, are sued to block specific websites, are sued to disconnect users. We have many of those cases, especially about website blockings. Now the argument here is different. Argument here is that, yes, there are voluntary measures, but those voluntary measures are not taking place. So this is what, for the right owners argue, they are rare, and we don't have enough of them. And even if we have them, they lead to unfair conditions, so value gap and video sharing platforms. Now, so the proposal is here, okay, this entitlement to sue to get assistance is something that actually benefits, because the measures that you would otherwise have to agree upon in the negotiations, you now can force by means of an injunction. So you go to the court as Disney, and you ask AT&T, who you name as defendant, hey AT&T, would you please block access for your own customers to the Pirate Bay? Why? Because the Pirate Bay is infringing my rights. Maybe even the users of Pirate Bay are infringing. And of course, you're able to prove the only things you have to prove under that particular provision, which is the fact that AT&T is an intermediary, that's obvious, and that his services are being used by a third party to infringe. Yeah, Pirate Bay and also users potentially are using it, so you can get the website block. Now the problem is, apart from the fact that you are able to do this, is that you go to the court and as the practice stands today, you only bear certain costs. So for instance, Disney will have to pay for its own cost of going to the court, okay? Will also pay the cost of, legal fees, but nothing else. So the highest cost, of course, with website blocking is being incurred by intermediaries. Why? Because if the type of website blocking that we are talking about is deep packet inspection, many intermediaries won't have, especially smaller ones, won't have the technology. So they have to pay a big fixed cost to actually get the technology in-house and maintain the technology because the blocks will be coming. And really, we're talking about 5 to 6 zero sums here when we talk about these website blocking technologies. And actually, very interestingly, those technologies are very often more expensive for smaller intermediaries than they are for bigger ones, which is kind of counterintuitive because you would think, well, if you have a huge user base, you would pay more. But in reality, because sometimes your infrastructure can be built very differently, it might be actually very more expensive for you to license it than to, for instance, have it produced in-house. So the consequence is that the Disney has incentive to go to the court anytime the benefit of the website block is higher than, let's say, 10,000 euros, which is cost of legal representation and the court fees. So anytime the benefit is higher than 10,000 euros, you are happily going to the court and getting website block, despite the fact that the potential cost can be 2 million, because the ISP is incurring a huge cost. But of course, from the right owner's perspective, it makes a whole lot of sense, right? I'm egoistic, I'm self-interested. I would do the same, being a right owner. But it, from the policy perspective, doesn't make any sense, because if the benefit is really smaller than the overall cost, at least the direct cost, then we are wasting resources, nothing else. So it's for the benefit of society to redesign, if we want to keep this, to redesign this particular remedy by making the right owner liable to pay not only his direct cost, his own legal costs, but also the cost of intermediary. Because then the right owner goes to the court and he has to pay his own legal representation costs, court fees, and the intermediary's cost, right? The consequence is that any measure he applies for should probably yield benefit that is higher than the direct cost. So it shouldn't be welfare decreasing, at least from the static perspective, right? Because he already makes that calculation. Interestingly, courts are, so something similar could be happening if courts would moderate and would require effectiveness that is at least as big as the benefit, right? As the cost of intermediary. So they would look at the cost of intermediary and look at a potential benefit, and they would say, okay, they outweigh, so it's a welfare increasing. Courts abdicated on this. The reason for this is because it's impossible for them to estimate the benefits. How can a court actually estimate what is the potential benefit of the website block? Very often, even the right owner himself has no idea how it's increasing a sale of a particular. So if you block a website that is selling fake Cartier, how can you estimate what is exactly the net benefit that you're receiving from this particular website block? It's not as easy, right? And for court, it's even more difficult. It's rather impossible, right? So that's why the only party that actually can make that estimation here is the right owner. So right owner, if he's exposed directly to the cost, the direct cost, he can try out. He goes to the court, gets one website block, pays marginal cost, which means with the first block, he pays the whole fixed cost. It's expensive. So that creates a collective action problem, but that's good. because we want to have those measures tried out collectively, so that's not something bad. So goes to the court, tries this out, and of course he has to keep paying. So if it's maintaining the website block and there's some marginal cost involved, he has to keep paying that bill. And if he still thinks the benefit is exceeding the cost, he will just keep paying for the website block, and the website block will be there. But if he realizes that this enforcement technique is completely meaningless, because his costs are 2 million euros for the last 5 years, whereas the benefit was very small, he will just abandon this. Whereas under this scheme, he will never do so, because 10,000 euros is just nothing, it's peanuts. So it will be always a good idea to go get for the block, and since he has no cost, he doesn't see it in his balance sheet in the years to come, it's absolutely one-time affair. He goes to the court, he gets it, and there are tons of blocks out there, and intermediaries have to maintain them. So the costs just pile up, even though the blocks become completely unimportant to the right owner who sued for them in the first place. So that's a big problem, and it can be tweaked by making the right owner pay for the cost of intermediary. Now you can ask, why intermediary? Why not to the state? Well, the reason is because if you would pay to the state, you double the cost, because the intermediary would still have to pay the cost. But the problem is, of course, it's not easy sell, right? It's not easy sell that intermediaries should get compensated for something like this. But the good thing is that if you go to history, you find confirmation for this economically intuitive rule. So I told you about Norwich Pharmaco orders. Norwich Pharmaco orders, apart from the fact that they introduced this remedy to get disclosure of information from third parties, they also had one important feature. And that feature was that a person who provided information always had to compensate the person who released the information. Of course, the cost of complying with the disclosure order is probably smaller than instituting website blocking, but this was an important principle. And you can see, for instance, Lord Cross was saying in this famous case, the full cost of the respondent of the application and any expense incurred in providing the information would have to be borne by the applicant. And you see, when you look at the language, that compensation for hardship, as this was understood, of course it's difficult to sell website block as hardship these days, is part of very justification of obligation that is imposed, because, and this is rephrasing what the court would say, equity mandates that you release the information, but equity also says you have to offer something in return for inconvenience that you cause to the third party who just got mixed up in transaction and did not do something bad on its own. If we don't do this, we get stuck with the following, which is reality now in Europe, which is basically having symbolic enforcement. As enforcement of making gestures, is getting gestures. Because you get a website block, maybe it's effective, maybe it's not. There is some evidence saying it might be slightly effective, some other evidence saying it's not necessarily effective. Honestly, I wouldn't like to be the one who has to estimate as being the judge. I want the party to make that estimation. Why to burden the court to make these estimations? So unless we introduce something like this, and you see that the courts are abdicating on this exercise, this is from the Cartier 2 decision in the UK, so it's a website block that is relating to trademarks, and there the court is saying there is no requirement for the claimant to show that blocking access to targeted websites an issue is likely to reduce the overall infringement of his trademarks. Absolutely no requirement. So, to sum this up, if this policy of having assistance from special remote intermediaries should make any sense, you need to have a compensation inbuilt, because otherwise intermediaries are not making the cost-benefit estimation before they go to the court, or actually making one, but that one is not in line with the general policy. So they go to the court even for welfare decreasing solutions. So you have to outsource the decision to the court. One of the opportunities of this remedy is the impact on voluntary measures. So of course, what happens is by having this remedy, you impact how the deals on voluntary measures are being struck. because you completely change the bargaining frontier, because you know what you can get if you go to the court, even if you don't agree. But also intermediary knows what he will get compensated if he goes to the court. So the bottom line of this, either repeal the Article 8.3 or reform it by redesigning it and making the cost something that has to be borne by the right owner. But the one problem that you won't remove from the system is the potential cost on innovation. And if you, and that basically ends up on your belief in courts and as being a good moderator for innovation and through defenders of future sources of innovation, because what the courts under this system are being turned to, they're being turned to standard setting bodies where they can create certain measures, and unless you have some people yelling at a court or at a court listening, that actually they see that potential enforcement measure here can have impact, huge impact on innovation, such as was the case in Open Wi-Fi case, where the Advocate General himself has recognized eventually that Open Wi-Fi is a potential source of innovation, and that's why password locking should not be something permissible under these injunctions from the innovation perspective, which in the in the EU case law is rather unusual to refer to innovation. You refer to fundamental rights, but not to innovation. In this context, unless you have this trust in courts, maybe this measure is not such a good idea. And that's it. If you're interested in more, feel free to either email me or follow me on any of these links. Thanks a lot.
Just to return to for a moment to the question of cost sharing, you didn't mention the Telecable ruling from the CJAU, in which, at least as I understood the ruling, the court seemed to suggest that the costs or the consideration of overblocking should be a cost borne by the intermediary. That in fact the internet access provider was expected to create a process whereby its customers could appeal to the intermediary to show that a block was overbroad. So I'm curious what you make of that in terms of your cost sharing analysis. It seems to me in some ways that makes it even worse in terms of allocating costs in an inefficient manner. But I wonder if you would agree.
So this is, of course, not in line with what the law is at the moment. So that of course. But why does it make it worse? Can you expand on that?
Just in the sense that now not only must the intermediary pay the cost of implementing in the case of website blocking, the block, but now it must also create a process and bear the cost of the process for receiving customer complaints and essentially adjudicating whether or not a block is proper based on proportionality and whatnot. So now the intermediary pays not only the technical cost of compliance, but also the cost of creating an adjudicatory process. Yeah.
But so this is indeed one of the consequences. So just to give some background to this, so one of the safeguards that the court rightly introduced was a possibility for users to be able to challenge far-reaching blocking, right? So if it overblocks, for instance, your website, which shouldn't be included in the block, you can, as a user or a website owner, you're able to go and get some relief. The thing that the court didn't think of is how to achieve this, because of course, the fact that freedom of expression is being tempered with doesn't mean that you have a positive action against an individual to get the website unblocked. So there are two different ways, and of course, common law, it's easier. So in common law, what the courts did, and they did it already before Telecable, they said, we will grant our injunctions with the Discharge Clause, and this developed. So first they have it only for certain type of cases, but then they're rather broad these days, which is good. And they basically introduced the Discharge Clause saying, if there is a user saying that this court order is over-implemented, or it shouldn't have been granted, you can come to me and I will reconsider. But civil law judge, coming from a civil law system, you cannot do it because you don't have such a power over shaping the actual order, right? So you just basically either reject it or grant it, right? You might suggest that this is going too far, but you cannot moderate it and rewrite it, and so indeed that's one of the consequences that in civil law system people say, and this is how, for instance, Austrian Supreme Court said, you can implement this kind of remedy is by contract, right? Since you need to have somewhere the claim, and from tort is rather difficult to construe it, you can construe it in the contract. So you will read the contractual provisions in light of freedom of expression by saying from the contract you have a right to not get overblocked internet access, right? But of course that creates a problem that suddenly now you sue the internet access provider, and the internet access provider now, let's say it says, okay, I overblock, so what do? There is a court order against them that is valid, and that is binding them. This is unresolved, you know. So there is no specific instance how to resolve this. In common law, it's easy, I would say, but I think in civil law it's rather difficult. And there was actually there are even more funny cases. In Slovakia, what happened is that because the intermediary was having its center in neighboring Austria, in Vienna, they were overblocking also for territory of Slovakia. So what do you do in that case? You know, you don't have a contractual relationship with a person who causes the overblocking. So it gets really difficult. And if this should exist indeed, it should be embedded in the court order system itself, as it's done currently in the UK. Otherwise, it just creates additional cost. And even I don't think it can be efficient anyhow, because I don't know how do you discharge yourself from the obligation to comply with the court order as an intermediary. So that creates definitely additional cost. That's definitely not well thought through. Yeah, that's a good point.
So continuing on the overblocking theme, sorry, I'm kind of struggling to articulate this. So I think you've made a very persuasive case that it is wise to put the costs on the rights holder because they have the right incentives to be efficient about when to continue with a monitoring effort. I'm wondering where you can put responsibilities if you also want the least overblocking outcome, which is different from the most economically efficient outcome.
Yeah.
So the intermediary has some incentives not to overblock, some because they want lots of stuff on their services, but that's relatively small. But it's the rights holder who has the necessary knowledge to actually avoid overblocking because they can exercise the human judgment to say when something is infringing or not infringing. So it seems, particularly if you're talking about a monitoring requirement like in the German cases, like in the rapid share cases, where what the court wants to happen is sort of algorithmic filtering followed by human review. It seems like if your goal is to have that be as accurate as possible and avoid overblocking, it's actually the rights holder who has the ability to make the right choices and accusations there. So I'm rambling a little bit, but I'm sort of wondering what you can tinker with in the allocation of responsibilities and costs to reduce overblocking as much as possible.
Okay, so I mean, first of all, I'm not saying that that country does not have the system, which does not have a system of this remedy, should institute one. I'm only saying if you have one, you should better redesign it. Or don't have it at all. So I'm not saying which is preferable policy there, because I think there are many empirical things that you would need to see, for instance, the voluntary measures, the claim inefficiencies there, and so forth. Now, one part of the inquiry about overblocking is, as I see it, is a separate consideration. So those are social costs that you definitely should control for, but there are conventional human rights exercise. But you look at a proportionality, you look at what you're trying to achieve with a block, whether that's proportionate as a measure and so forth. Now, I try to distinguish the two situations of remote and proximate providers because proximate providers are for those for who I see no role for these remedies because they do nothing, just rewrite existing notice and takedown into something that is not in notice and takedown policy, right? So that's why by arguing that stay down is actually going against its own aims, I try to suggest that there shouldn't be any role for these injunctions there. Now, it's different for the remote providers who do not have to act, and they have some measures how to tackle problems. And the question is voluntary measures the right policy, or is it the court order? And actually there, it gets tricky because of two things. So first, voluntary measures can be actually more harmful for fundamental rights than the court-imposed website blocking. Why? Because it's different if there is a right owner and the let's say AT&T agreeing that they block your website. I think you intuitively feel that it's a more problematic than if there is a court actually screening whether that website should be blocked, even if the person is not represented. So you see that actually human rights can actually tilt the perspective of the two, voluntary versus court imposed, into the perspective of the court imposed. Same with the disclosure of information. You know, releasing information without court order is something you might be less comfortable with as if there is a court screening happening. So, of course, there is always problem on the exposed level, implementation. And that's why we need safeguards. But they are not, as we have them now, they're not particularly perfect, but we need to come up with something. And it should be some affirmative sort of remedy. I don't have the solution yet, but I definitely think we need something. If we are serious about, you know, if we screen the court order and then we ignore what happens afterwards, it doesn't make any sense. So we should have something on also exposed, for the exposed phase. What exactly that should be, whether court discharge clauses are sufficient, I don't know, but there should be something for sure. Does that answer, Daphne, your question?
Yeah, I'm not sure what my question was. So, yeah.
That's difficult.
So you talk about remote providers and proximate providers. I wonder if you've seen any thought about the interrelationship between those two categories and effectiveness of the measure. Mm-hmm. So you see, for example, in the UK cases, there has been a rejection of including search engines, for example, within the scope of the injunction. On the theory, I think, that once you've got blocking by ISPs, then adding burdens to search providers is redundant, because if you can't reach the site through your ISP, then a search engine can't help you either. Yeah. But we have a case in France where the French court has imposed, under Article 8.3, an injunction that includes both access providers and search engines, seeming to think that, well, you know, what's the harm? Let's have everyone get involved. Yeah. So I wonder what your thoughts are about whether there's still room to argue about redundancy and effectiveness, because otherwise it seems like access providers, social networks, search engines, hosting providers, it seems like you could issue these injunctions against everyone, which creates more social cost than the simple scenario you have. So there can be everyone is incurring costs, and you have redundancy of cost rather than just the access provider doing it.
So we should also mention there is also one inverted case when this subsidiarity was considered, which is a German website blocking case where the court said unless you first do sufficient efforts to do something against the website itself, only after that you can come to us to get a website block. So actually, at the very beginning, one of my biggest problems with this remedy was its competition to tortious remedies. Because this remedy is very easy to argue. You don't have to prove anything, right? And I mean, that's like a dream of any litigator. So why would you claim secondary infringement if you can get a remedy of the same kind and there is no different cost involved in it? So of course you'd rather go for this than arguing on secondary liability grounds. So that was one of my biggest concerns at the very beginning. So one of the features that the cost reimbursement already introduces is that it makes it less attractive, but only in situations, and I here agree with you, in situations where the implementing measure is expensive. So website blocking would be really seen as, okay, you have to pay a lot of money as a right owner, so I really consider whether I go for website blocking vis-a-vis some other measure. Now, if this would create that the right owners consider different remedies and how expensive they are, against the benefits, that's not a bad thing. The problem is that there are some remedies that are very cheap to implement, but their social cost is very big. And there, I think, we can see those social costs in two different ways. One is the human rights cost, and the second one is innovation. So that's why open Wi-Fi, I think, would pass it's very easy to pay for password locking of open Wi-Fi. It's ridiculously cheap. It's nothing. The freedom of expression arguments can be made, but they're not necessarily too strong. Privacy, they could be made, but I'm not saying probably not very strong. Depends on the setting. So the only thing you're left with is innovation. So that's why actually I try to argue that you should instrumentalize innovation in the grant of remedies. And you should really think of the potential on follow-on innovation. So that would be the only conceptual category where I think you could think about those situations. But it wouldn't give you, if you believe or you hope for a structure where search engines comes only after, say, internet access provider, I don't think that would really happen. But that's a consequence of having that at the first place, you know. So it's, if you want to have that kind of system, you can redesign it, but you have to live with consequences. You have to mitigate consequences, but you cannot say that you basically deny the whole maneuvering space, because then you basically deny the whole remedy, which you can do and not give it as a policymaker. But once you have it,
you can insist that the remedy be efficient and effective. In other words, it's sort of like subsidiarity. You can say you may have this remedy, but you must choose. You must explain why the intermediary you are targeting will provide the most bang for the buck.
but why? Why would that be the case? I mean, let's say I'm the right owner, right? And I have option A and B. Option A gives me benefit of 10,000. Option B gives me a benefit of 20,000. Option B is more expensive. Option A is cheaper. Why shall I be now constrained on which choice I make? Rationally, I should go for a solution that gives more bang for the bucks, and that's aligned with what the welfare increasing solution should be. Of course,
I completely agree with you, but that your view only works if the courts were to adopt your approach.
Of course.
Then I agree with you.
Yeah.
That's great. But assuming the courts don't adopt
No,
that
of course.
approach,
Then of course.
Right.
If
Then a second best alternative would be to ask the plaintiff not to seek remedies that are not incrementally effective. Right. In other words, you should not be compounding social costs by seeking multiple redundant remedies, each of which has a cost, but some of which deliver no benefit.
But I think that one is impossible to do. So it's a policy that we can have. I mean, in theory, you can make that courts could be doing this, but I don't think they are capable of doing this. So that's why I don't think the policy as it stands. And I mean, if you are coming from the existing system, not from my upgraded system, then indeed, then you're right. I mean, then of course, then the problem is, I mean, that problem of having website blocks that are completely ineffective in the place even when the right owner is not interested is amplified because you tried out remedies against many other people. You're not interested in their remedy, in that particular technical solution anymore, but they still keep doing it because there's a court order without sunset clause that is forcing them to do so. So that's of course that's a big problem, and I don't think it will definitely increase only with time. So 20 years with this remedy, you will have a lot of those blocks out there, and it will be very expensive to maintain them. So unless you introduce something like this, at the social cost, I actually didn't think of this, but the social cost of this will be definitely high.
And thanks for this. Great talk and great project. I wonder if you could say a little more about the innovation piece. Mm-hmm. I think that's a really attractive and sort of very beneficial alternative way. But as a practical matter, can you say a bit about the sort of likelihood that either European policymakers or courts would focus on the innovation impact as one piece of what they ought to be looking at, and as a sort of advocacy matter, how you try to pitch that as the correct way to think about it?
Thank you. This is I really like this question. It brings me here. So it's I should start saying that I think it's of course outside of antitrust law. I mean, antitrust law, that's obvious place to look for innovation arguments. But in IP litigation, especially with the enforcement litigation, you don't really see innovation arguments coming up. This opinion of Advocate General, and it was one of the first to pick that up, this concept. I hope that they will be implemented by the court. And arguably, court is already using the thinking under a different label. And the different label is it's coming from TRIPS agreement. I think it's one of those introductory provisions on remedies, and it's saying something like remedies should be always proportionate, blah, 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 and they should not create obstacles to legitimate trade. And the court is actually using this kind of language to, for instance, reject blanket filtering. So not targeted, but blanket filtering, and it's saying that this is creating obstacles to legitimate trade. And there's one pending case that concerns offline intermediaries when this might be, for instance, also important. So the court it's not that the court is it's completely ignoring this dimension, but it's not trying to instrumentalize. And I think this has to change, and the change might be actually driven by a completely different part of enforcement. So think of standard essential patents. You know, in the US, since injunctive relief is more flexible thanks to eBay, US courts are able to deny or to condition injunctions, for instance, in Broadcom versus Qualcomm, in one case where they introduced injunction with a sunset clause. So they said, yes, we issue injunction against Qualcomm, but you have a couple of months to basically invent around. So we don't want to basically give you this hold-up position, the right holder. Of course, you get compensated for this part, and then injunction will enter. Currently, there's very little debate about injunctive relief and how injunctive relief itself should be made more flexible, even against infringers. So this is not infringers, but even against infringers. And I think this will change, because so far we're trying to use antitrust policy to moderate it from outside. So that's why we had, Huawei case. We tried to say, well, it might be abuse of dominant position in some such situation if you seek injunction on SEP. And I think we need a solution in IP itself. There's a fantastic example ongoing now in the field of open source. When there are people who contributed to open source, and of course there's a lot of incompliance with open source licenses out there. And you cannot chase all of it. And what these people do, or this one particular person does, he chases those people with the very obvious kinds of incompliances, not license is not attached or something like this. And he's chasing them, and basically he's turning itself into sort of a copyright troll. And what he's leveraging only is the injunction, because he has this hold-up position where he can basically stop your product because of this incremental part of code that is in there, which you cannot just take out. Now, I'm not saying that you should not live up to the standard of the license under which the code is being distributed, but maybe the fact that it's such a small part should at least give the possibility of injunction with a sunset. And what is the consideration that drives you to this? Is the legitimate trade. What is behind the legitimate trade is the innovation. You don't want to stop important device from entering the market just because there is one very small thing. And there are many incompliances even on the major operating systems and on smartphones. And we don't want to stop that innovation just because there is, technically speaking, some infringement ongoing. So I think this will come. It has to come, because we cannot use just the antitrust law to moderate for this. But it's not coming yet. But I'm hopeful. I'm optimistic.